are on record.
Item number 12 on the first appearance docket, Your Honor, is Stephanie McCrea.
Correct.
Is your true name Stephanie Erin McCrea?
McCrea, yes.
First name spelled Stephanie?
Yes.
Middle name Erin?
Yes.
And last name Mccrea?
Yes.
And your date of birth?
3/27/79.
Making first appearance this morning, Your Honor, on charges of rape of a child in the third degree, force, and tampering with a witness.
All right, Ms. McCrea, you have the right to remain silent. Anything you say can and will be used against you. You have the right to a jury trial on the charges the state brings, and you have the right to an attorney assist in your defense. Mr. Thayer, I'm assuming you're here at least as a courtesy this morning, or have you been retained yet?
We're retained, Your Honor.
All right, thank you. One moment then while I review the probable cause. The indication here, rape of a child, third degree, tampering with a witness, sexual misconduct with minor 1 and 2. All right, court finds probable cause established. Position on release.
Your Honor, the state's asking for $500,000 bail. The argument against bail in this matter will be that the defendant was employed with the same employer for a long period of time. She has ties to the community. But we'd indicate to the court that this is a very serious crime for several reasons. This person was trusted with the children of the Evergreen School District. Parents would send their kids to school thinking that they'll be safe, including extracurricular activities outside of the school. And in this case, this teacher specifically took advantage of students in that way. The students spent time with her outside of school, including going to the movies and other activities that were not school-related. Specifically in this case, one of the incidents took place at a time when she did have the trust of the parents, did take the kids out to the movies, and met this victim in her home during that time and had sexual contact with him.
I'm assuming she's on leave of some kind then from that job.
She is on administrative leave, and I think that's a very important thing for the court to understand as well. After she was placed on administrative leave, she continued, and she knew that the allegations had been brought to the police. She continued to have contact with this victim. She had made a contingency plan that if they were ever contacted by law enforcement, that they were to create a fake Facebook page with aliases, which they did. She coached him on how to respond to law enforcement if he was contacted. She also was very manipulative of this victim. She indicated to him that she was going to commit suicide and attempted suicide. And so we think that this is a really significant crime, and the court should take it very seriously. Unfortunately, we've had opportunities to hear from people who don't think it's as serious because the victim in this case is a male, but any parent would understand that the fact that whether the victim is a male or a female, this is extremely serious. She was in a position of trust and should be treated thus-wise.
Some of the facts that you're mentioning there aren't specifically in the PC statement, but I'm taking those as representations by counsel with the duty of candor to the court.
Yes,
so.
Absolutely.
Mr. Thayer.
Well, Your Honor, Stephanie's 35 years of age. She has no prior criminal record. She was born and raised in Portland. Went to school.
At least one child?
One has one child. Went to
old?
I think he's 9.
Yes.
He's 9 years old. And she's never been in trouble before in her life. She taught at Evergreen High School for 8 years. There was no problem until this situation arose. It's situational. There's no reason to believe that she would be a risk to reoffend if she were released on recognizance. Rule 3.2 creates a presumption of release on recognizance unless the state can establish that she's a risk to reoffend or is a flight risk. And we know she's not a flight risk because she voluntarily surrendered yesterday after I made arrangements with the detective to have her turn herself in down at the Sallyport at the sheriff's office.
Does she own her home?
No, Your Honor.
No, she doesn't own her home, but she has parents and family and strong community ties. There's public support for her, family support for her, and based on the presumption, I think that there's no, and the other thing is, counsel mentioned that there was some kind of communication between her and the alleged victim regarding what to say or what to do, but that was before she was brought before the court, and if she's instructed not to do that as a condition of release, no contact, of course, there's no reason to think that she wouldn't follow the court's directive. So I think she should be released on supervised release. The request for $500,000 bail is political, pretty transparently political.
Well, one of the factors that the court can consider under Rule 3.2 is protection of the community. And so I guess one question I would put to you is, aside from a sexual assault protection order, which is being requested, what other assurances can be provided that during the pendency of this case that, I mean, obviously if she's on administrative leave or whatever from the school, she's not going to be there.
Right.
It may be episodic or with this one particular
Right.
alleged victim. But I guess the court is asking if there are, what other assurances or proposals would there be to help mitigate on that particular factor in Rule 3.2, protection of the community?
Well, there's no showing that she's likely to reoffend. There's, you know, this is the only thing she's ever been brought to court for before in her life. It was obviously situational. So as far as assurances, the court can require her to maintain residence with someone like her mother, or she could live with relatives. No contact with the alleged victim, of course. No drugs or alcohol. The screening done by corrections shows that there's no drug or alcohol problem. Maintain contact with counsel, the usual things. I mean, there's no showing here that we have to any cause to have any concern. And of course, if anything happens, she can be brought back and redirected.
Your Honor, if I may.
You may.
The court asked, I mean, one of the things that was mentioned was the fact that she has no criminal history, and the court is well aware in these cases that oftentimes in these types of cases there is no criminal history. What we do know is that this defendant had access to lots of students during the time that she was trusted with these students. Also, we also know that while on administrative leave, while contacted by her agency, after doing that, she still made contact with this victim. And that's
in fairness, that's not in the PC statement, though. I don't have an indication of contact after that. I have some indication.
Your Honor, I think that the court can look at things outside of the PC statement, and it is with candor that I indicate this to the court. She was placed on paid administrative leave, made up a fake Facebook account with this victim, and continued to talk to him about issues, including promises of them being together forever. These are very serious allegations, and I think that the court needs to look at them as such.
Right, and I think that the court can prohibit her from having contact or using the internet, using media devices, if the court feels that that concern is going to be valid going forward, which I don't. I can assure the court she's going to follow the directions of the court, the conditions imposed. This is a good supervised release case, and we hope the court will do that.
All right, the court takes into account the factors under Rule 3.2. There's, frankly, factors weighing on both sides sort of all over the map on this. Under the circumstances, the court's going to set bail at $40,000 plus conditions. I am going to enter a sexual assault protection order, ma'am, with respect to the alleged victim, initials DWF. Let me make very clear, it's going to be here in writing. But this order will prohibit any kind of contact, that is direct, indirect, electronic, through third parties, you name it. This court will not tolerate, given the nature of the circumstances, they're somewhat explosive, this court will not entertain any deviation from that order whatsoever. So any violation of that whatsoever will result in you being brought back before the court and having to have those addressed. So while these charges are pending, absolutely no contact with that alleged victim. You'll get a copy of that order. I'm also going to include and restrict use of electronic, internet, and media. I think that is appropriate under the circumstances. We're going to set over to February 11 for arraignment.
Your Honor,
Judge, do you have a note or a release order?
we usually set conditions at the time bail is set.
Bail's going to be set today.
If you want to go back and work with Ms. Welch and set conditions, we can come back and wrap up a release
All right.
order.
Thanks, Court.
Your Honor, is she able to have contact with her minor son at this time, or is there no contact with minors?
State requesting any restriction on her contact with her own child?
No, but we are asking for no contact with all other minors.
Absolutely no contact with other minors other than your own child while the charges are pending. Okay?
All right.
Thank you.
Let's go back and we'll work with Elise here to get.
Item number 15 on the first appearance docket is Lee Whitaker. Mr. Whitaker is in custody. He's not been transported down at this time. At this time, the state is handing forward a motion in order for exoneration. Your Honor, I have asked the jail to strike him from the transport list.
Stampede, huh? All right, I've signed the order of exoneration.